of the decedent's death, okay? Because we're talking about how much it was valued at when they died. Then you can use that. But if they died 10 years ago, and there is nothing to indicate what the property was valued at 10 years ago, what do? You have to do some research. See what properties were going for at the time the person died. All of those things are important. The affidavit itself also must list not only the names and addresses of the heirs, but it must also list what their proportionate shares are in the property. If you have 4, right, then that's pretty easy. 1, 4, 1, 4, 1, 4, 1, 4. But if you have children who predeceased and they had children, one of them has 3 children, now we have 1/4, 1/4, 1/4, 1/12, 1/12, 1/12. That's easy math. Okay, we can do that math. But when you start including 10 or 15 people, and you have, 2 or 3 people who have predeceased, you're going to run into problems. And you just might not be able to do a small succession by affidavit. What'd you say, sir?
I gather that to be sooner the better, huh?
Yes.
I have looked at the assessed value on the tax statement. And you just mentioned that you might have to go back, so many years to find out what was the value of a certain property at that particular time. What does that assessed value really mean? And is it a percentage of the true value or what?
Now, your name is Mr. Brown, right?
Yes.
Mr. Brown. Mr. Brown. I don't work for the tax assessor's office, but I think they use some formula, okay, to come up with that value, and it's just an assessment. It is not the market value of the property. I know that. Oh, here he said 10% of the fair market value.
Okay.
That's what this gentleman said.
Thank you.
All right.
I never heard it mentioned on this.
So, yes, ma'am.
If the person is over more than 25 years and then, that person died, you still have to have the same information that you just talked about?
Yes.
Oh, goodness.
Yes. The affidavit of small succession is a document that it is basically where the affiant, the affiant, the person who's given the information is swearing, okay, and that all of this information is true and correct, under penalty of being punished civilly or criminally. Okay, and remember what I said. Succession is the transmission of the estate of the deceased to his successors, whomever they are, whether they are heirs or legatees. Heirs if he had no will. They're called legatees if there is a will. Okay? The estate, we have to know what his estate was. How do we know who his heirs are? Because we're swearing in here that he was married, he had children, these are the children. You have to know all of that information to determine whether or not what's contained in here is correct. Yes.
I got a question. Oh,
Oh, I'm sorry. He has a mic. Come on, sir.
I got a question that you were saying about the heirs. My mother had 8 children.
8?
8.
Okay.
4 boys and 3 girls. 5 boys and 3 girls. And all of them have deceased but me.
Lord.
All of them gone.
Come on. Do I need to get a pen?
Do you need it?
Come on. Get a pen.
And truly, the only thing I got is
Okay.
that's it. They didn't have no uncles, they didn't have nothing.
Okay.
So what would my situation be for that?
Okay. There is a house.
Yeah. She went for will.
She left a will?
Yes.
Oh, that's good.
Yeah, she left a will. She left a will.
Did she leave it to you?
Well, I'm the only one left.
No.
When she passed, my sister was with her.
Okay, when she died.
When my mama died, my sister was up. We all had our own places, you know. And my sister died,
Okay.
you know. And I came up there from New Orleans from Katrina. Katrina wiped me out down there.
All right, let me ask you this. At the time your mother died, who was living? How many of you all siblings were living?
All of them.
Jesus. Then, okay. In her will, is it safe to assume that she left everything to her children to be shared equally?
They left me and my other brother executed, co-executed. I got it right here.
Yeah. Okay, so here's probably your situation. Everybody, all of those children, your siblings are included in that succession. And here is why. Because at the time of her death, all of your siblings were living. And so her estate transmitted automatically. Dead people own nothing. Okay? So the moment she closed her eyes, whatever she had willed to you all went to you all. But you were not legally recognized yet as owning. And so they owned it, your siblings, at the time they died, and so it transmitted to their children. Okay? So all of them are going to be included in that succession.
Well, how do you resolve that?
You have to open the succession.
You say you have 2 different successions. I'm trying to figure out.
It sounds like what you're going to need is not a small succession. It will have to be judicially opened. Okay? Because it's quite complex. Small succession is not meant for that type of situation where there's probably going to have to be an administration. She appointed you and a sibling as co-executors of the estate. It's probably going to have to be opened under administration. And small successions by affidavit only apply to intestate succession. That is successions where there is no will.
I think someone's over there first.
My question is kind of like that, and you may have answered it because I think about my family. Of course, we all went to Christmas dinner at my grandmother's house, but that was my aunts and uncles and their kids. And once you get beyond their kids, I don't even know who these kids are, to tell you the honest to goodness truth. And I'm sure that gentleman doesn't either, because our families are on the East Coast, the West Coast, and that sort of thing. So does it get to the point where you can't figure out who, I mean, does the judicial option give you an option to jump over trying to actually perjure yourself? No.
No, sir.
No, it does not.
No, sir. What happens is a curator has to be appointed. Someone knows something. You know that you have a brother, you know that you have a sister. They may have died, you know they had children. Okay? Some of the children may have died. Somebody knows something, right? And so when you get to the point of not knowing where this person is, are they alive, are they dead, then that is the point that you have to hire a curator. And what that means is you petition the court and you request that the court appoint someone to go and find out this information. Not that they have to find it out, but that they must make a diligent effort in locating them and finding it out. And the curator is the person who is representing those absentee individuals and has to come back to the court and say, look, Your Honor, Judge, I sent letters to the last known addresses. I put an ad in the paper in the city where they were last known to have lived, and I got no response. I got no green card back. Okay? You have to show that you made a diligent effort to find out where those people were, who they are. And so you're going through the court proceeding. You're going through the court process. Small succession, not for you. Yes, ma'am. Oh, I'm sorry. Tell me where the mic is. All right.
I have a two-part question. One, and I'm gonna make it short.
Okay.
One, does it matter if one of the owners of the property died prior to, like my father died first, and then my mom died? Okay. The second part of the question is, once you, and I've been making notes, once you obtain all of the information that you need for the affidavit of ownership, you submit that to the 19th JDC?
All right. I'm gonna answer the last question first. Okay. You must file the affidavit of small succession along with a certified copy of the death certificate in the conveyance records in the parish where the immovable property is located. Yes, ma'am. You record it, okay? And what happens is this serves as your deed. FEMA, the bank, anyone dealing with you on this property can rely on this.
Professor Jackson, does a judge have to sign that affidavit?
No. No. And the affidavit under the Code of Civil Procedure is not required to be in authentic form, which means that it's not required to be executed before two competent witnesses. Okay? It only says a notary. All right? And at least two affiants. Right. And the affiants are the heirs, okay, who are coming to you, or coming to the attorney to have this done. At least two of them. If there is only one heir, then the second affiant is a person who knows this deceased person and knows all of the information that is contained herein. I confused you. The two of you can sign it, but you will list all of the heirs in here. Okay? Yes, ma'am.
Good afternoon. For those who died back when inheritance taxes were due, and the Louisiana Department of Revenue will deem them due prior to 2004 or whenever it was, though it's supposed to prescribe 3 years, so that's prescribed. You don't have to go
Yes,
through
ma'am.
them.
That ended in 2010, I believe it was.
Okay. And the other question I had was, if you have heirs that are willing to quitclaim deed the property so that maybe another heir can proceed with the FEMA processing and repair of the home, do you have them to file the quitclaim deed first in the records, or is that supposed to be filed within the succession?
If it is an issue of succession rights, it should always be filed in a succession proceeding. I'll say that first. The second thing is, I'm not very familiar with quitclaim deeds, but it sounds like what you're asking is if, let's say there are 3 heirs, and one of the heirs says, you know what, I don't need this property, I'm gonna give my interest to one of the remaining heirs. Is that the situation? Okay. That can be done within the succession proceeding by what's called an act of renunciation. In other words, you are renouncing your rights and interests in this succession, but you must do it in favor of this other sibling. Because if you just do a simple renunciation, then you're going to be treated as though you predeceased the decedent. And if you have children, then your share is going to go to your children, not going to go to your siblings. Okay?
I'm talking to my niece and nephew about that same thing, of their heirs also. And they all agreed that they will sign something or whatever they need to do, that it all come to me so I could have it changed over.
Yes, sir.
Can that happen?
Yes. That's exactly what I'm
Well,
talking about.
they will do that.
Yes, sir.
You know?
Just a second. But still, you can't do the affidavit by small succession
No, I really don't.
because you have the will, right?
Yeah.
Okay. Yes, sir.
Just want to rule out the possibility. I think I, got it from your prior conversation that a newspaper notification is not sufficient to find out who the heirs are.
Say it again?
A newspaper notification is not sufficient to find out who the heirs are.
To find out who the heirs are. As the curator or?
Yeah.
Are you, okay.
Yeah, the
All right.
court-appointed curator.
The court, that's what the court appointed
That's the
curator
only
is
way.
doing.
Okay, you can't say what I put notice in the paper, I'm looking for you.
That's what the curator does.
That's what the curator.
Yeah,
You can't do it as an individual.
No.
No, one more quick. Have brothers with the mother's name. Okay. I'm in the real world here. My dad was a Rolling Stone. Whoever he laid his hat to the home. Simultaneously, okay? The other laid his children, okay, which he acknowledged, and I didn't find out until I was years old that I had a brother, But, so, what are their rights?
Okay. All right.
How did you get them those?
If those children were acknowledged by your father before he died, then that's one thing, right? If they were not acknowledged during your father's life, they have 1 year to prove filiation after he died. Okay? If they cannot prove that he is their father, then they're out of luck. That's the bottom line.
1 year to death,
Yes.
not the beginning of the proceeding.
No. 1 year death.
Thank you.
One thing that I wanted to point out, I want to get to everything that has to be included in the judicial process. One thing that I wanted to point out is this thing with FEMA and co-ownership of property that has been damaged in a disaster. If you co-own and one sibling is living in the house is damaged, FEMA has the right to presume that the person who is in there, if they have been there for a year or more, has been authorized by you all to manage that property. And they can send the check to them. I'm going to tell you what it says right here.
Of ownership, and I've been in the house 72 years. I've lived there my whole life.
Ma'am,
Yes.
ma'am, this right here says, in the absence of it, and it's small succession and movable property damaged by disaster or catastrophe. Okay? It's Code of Civil Procedure Article 3422.1. The provisions of this article shall apply to a movable property subject to a small succession proceeding that is damaged by a disaster or catastrophe for which a declaration of emergency or federal declaration of disaster or emergency was issued. In the absence of a written agreement between co-owners for the use and management of such movable recorded in the mortgage records for the parish in which the movable is situated, any public entity or agent of such entity may conclusively presume that a co-owner in possession of the immovable for more than 1 year has been appointed by all co-owners to manage, administer, repair, reconstruct, and restore the immovable. And to receive, well, hold on, and to receive, disperse, and account for funds given him by the public entity solely for the purpose of such repair, reconstruction, and restoration. I didn't write it, I'm just telling you
I
what's
just
in
need
the
that.
book.
Where can I find that code? Where can I find it? Because they turned me down.
The Louisiana Code of Civil Procedure. Yes, ma'am.
This highlights a very good point, like, in terms of
I didn't write it, I'm just telling you what it says.
Like, it's a good point you're making about what is written and like what the FEMA agents actually do. Isn't always consistent, right? So like,
And-
it's a good point.
Right, I mean, now y'all, wait, I don't work for FEMA either. It's Code of Civil Procedure, Article 3422.1. Yes.
3422.1.
Do you want to talk about, you want me to go with it? All right.
I would just say this, if you're having a problem with FEMA recognizing Louisiana law, it's not, this is projecting, it's not in here. If you're having a problem with FEMA understanding Louisiana law, have someone draft that like up in a letter, an attorney or somebody, and saying, here's the law, and demand that they recognize the law.
Okay.
It doesn't matter, they have to follow the rules, or, yeah, for Louisiana. Yeah. That's true, they don't know. Yeah.
Have no idea what is involved with FEMA. And this is what happens. You have these kind of arbitrary.
Yes.
Does it make a difference that that says may instead of shall?
In what?
It says that the outside entities, yada, 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 yada.
Yeah, they may conclusively, right,
But
they
it
don't
doesn't
have
say
to.
shall. Okay, there you go.
Right, may is permissive. Yeah.
That's why they're turning it down. Yeah.
No, wait, let me give you the situation, okay, that arose just a week ago. There are 3 heirs, and they had gone through the succession process and had been recognized as owning their mother's property, okay? One female lived here, one lives in Houston, and their brother was an ex-con, right, who had been released, and they said, you know what, the house belongs to all of us, you stay there, ex-con brother, okay? And when the flooding happened, ex-con brother files an application with FEMA, and at the same time, sister in Houston files an application so that they can get the money to fix the house, right? The brother who lives in the house, and he's probably been there for a year or more, right? Is not very trustworthy. And they don't believe that he's going to use the money to make the repairs to the house. Sister who lives here contacts FEMA to notify them. There are 2 applications on the same house. My brother is in the house. We can't even talk to you, ma'am. Okay? We can't even talk to you. So she comes here, and that's her fear, that they're going to give the money to the brother. I get on the phone with someone from FEMA, and they said, well, you know, quite naturally, we should give it to him because he's living in the house, right? And I explained the situation, and it just so happened the brother refused to allow the FEMA inspectors to come in and inspect the house. Okay? And the person from FEMA tells me, whoever allows FEMA to come in and inspect first will be given the check. And so I advise the client, and I tell her, look, ma'am, this is what they're saying, and I believe you need to contact the sister in Houston, obtain a power of attorney to handle this situation with FEMA, and you allow the people to come in and inspect the house. And FEMA is going to write the check to you or your sister. I believe it's the sister who filed the application. That's what they do. I mean, you know,
Can I just say one thing? You introduced this whole problem with, they went through the succession and these three siblings had the property.
that's right.
I don't know if we got that, I'm sorry, I don't know if we got that from that lady sitting there. No offense, but she just said, I've been living there for 72 years. I don't know she has the other succession part.
Oh, right,
That's
right,
what
right.
the problem is.
Okay.
And that's why she's having problems.
Exactly.
And so I don't think she understands that. I think that she's confused, but she's left and we can't tell her that. But
Yeah.
I wanted to tell, that's what the real problem is, I think.
Right. You have to be able to show ownership. Okay? And the only way that you can show that ownership is if you have a judgment of possession, you've been through the court system, or you have an affidavit of small succession. Yes.
That's what, I'm glad she brought that point up, because we worked with a lot of people after Katrina, and they had been living in the family home, but they had never been placed in possession. They had never done a succession. And so that's why we have the small successions by affidavit, and we do successions for people, because it doesn't matter how long you've lived in that house. If you were never placed in possession, you can't show ownership, and FEMA will not deal with you, and FEMA will not assist you.
That's
And so
right.
that's the difference between her situation and the other person's situation, is because, right.
That poor lady's been in that home
Right.
for 72
That's
years.
why we were fighting for the small succession,
That's right.
because people
Exactly
were, had been living in homes for years and years in New Orleans, but they were never placed in possession.
That's right. And when you have 2, 3, 4 generations that you have to go back and, you know, crawl through, it's hard, y'all. I mean, you know, and it takes some time to straighten all of that out. But it has to be done.
Yes, I have a question. What are the costs associated with the affidavit, filing the affidavit with the conveyance records? Do you have a ballpark number?
To record
Parish.
something downtown, it used to be around $70 or $75. Okay, don't quote me on it, but it's somewhere around there. It's a lot less than judicially opening the succession. That is between $480 and $485. Okay.
Question. So let's say there was a situation where succession was opened, but it did not include immovable property. It only included, yes, and that's my question. So you have an attorney who opened succession for a person who tells the attorney his wife passed. So they bought the house together. The attorney does not include the immovable property, only includes the deceased person's bank account. How can that be a valid succession? And is it a valid succession? And how do you rectify that problem for the remaining heirs who should have been placed in possession of the home, but the attorney, by, I don't know if it's omission, or negligence, or what, did not inquire or did not even pursue the information to include that in the succession?
Okay, so there are a whole lot of issues there that have been raised, but let me answer the question about the succession. you have to file a petition to reopen the succession and to, have that property, brought back into that original succession. So it was validly open, but it did not include the entire state.
Capital. But now, the other question is, again, that's a lot of changes. At one point, you had forced heirship, and then the forced heirship law goes away. How does that affect that person who later, well, the forced heirship law, one point, you had forced heirship, they were no longer protected by forced heirship because the law changed to allow a person to leave a will and not lose the forced heirs. How does that affect the situation? That person, the second owner of the property passes and leaves a will in contesting the forced heirship of the person.
Okay, so at the time the will was written, the forced heirship laws were not in place.
That's correct.
But when the person died,
No, the will was done after the forced heirship laws were rescinded. At one point, you could not omit a forced heir.
and
But then
you
the law changed.
can't now.
Exactly.
Right.
But I'm saying there was a will done to try to circumvent the forced heirship law.
Well, first of all, the law that was in effect at the time the will,
Of the succession,
no, at the time the will was written, right?
Okay.
Is going to apply.
At the time the will was written, even
Yeah.
though the person deceased, even though the person they were, what I'm trying to say is they were married, as the second person left a will, but the first person in the house died without a will. So the succession was incomplete without putting the heirs into the succession of the house. The second person dies with the will.
Let's talk after, because that's a lot of convoluted stuff.
Yes, it is.
All right. My time is up.
No, I'm not.
You're really?
Thank you. That's it.
One question, real quick. I was wondering for a second if I could just click on your affidavit website. Is there a various jurisdictions they have?
But that would be so great. I think we're on.
Yeah, I mean, I'll.
Thank you. Appreciate it, great.
Actually, so this is like, and that legislative person's methodology.
Thank you so much. Thank you. Thank you.
I spent first half, I got real quick. Yeah, it's like a short point. Again, yeah. And so I don't know how interested in I hope. No problem.
Oh, you also use the keyboard, okay? You don't use the keyboard. Use the keyboard.
I'm going to grab that, be right back.
Yes.
Really, huh?
That's it. Someone stops on it. Do me a favor, can you watch for any questions that pop up?
So, you're gonna pop up.
If you see a question from somebody pop up.
In this area here?
Actually, it's gonna be up here in this section.
Okay.
Then just let him know if there's a question, read out.
Okay. All right. All right, guys, I'm going to get started. Y'all didn't hear me, huh? Y'all hear me? Oh, that's not for the mic. That's not the mic. Oh, that's not for
All right,
this room.
folks, the next
No, it's not.
presentation is going, it's starting. Good.
All right, guys, go ahead and get ready to get started. All right, guys. Speaker here. It's for you. All right, guys, so I'm going to go ahead and get started. We're going to talk about SBA loans and the SBA discovery towards the disaster recovery loans for the SBA. My name is Kent Smith. I'm the Director of Small Business Development Center here at Southern University. What we actually do, we work with small businesses and entrepreneurs who are actually getting their businesses started. They already have their business up and going. They need counseling. They need questions for answers for his taxes, as far as the business is concerned, for the business's growth. So through that process, we actually work with a lot of businesses who actually have applied for the disaster recovery loan. So today we're going to talk a little bit about that, kind of clear some of the questions up about the disaster recovery loan compared to the traditional SBA loan. Okay. So with that being said, we actually partner with the SBA. SBA and LED are a stakeholder to the Small Business Development Center, and so they actually fund that particular program. With that being said, there's a lot of misunderstanding between SBA and FEMA. What would FEMA give? What would the SBA give? Well, FEMA denied me. FEMA gave me X amount of dollars. They gave my neighbor, X amount of dollars. You see a lot of that on the news. And the thing about FEMA, it is the Federal Emergency Management Agency. They manage the emergency. That's what they do. They don't rebuild your home. And that's kind of a misconception. People say, well, I had this amount of flood, this amount of water. They think FEMA's going to come and actually put the home back together again. That's not what they necessarily do. They manage the emergency. So FEMA makes your home livable. So livable could be sheetrock, it could be post. You can live in the home. It may not be where you want it to be, but that's livable. So that's a difference there, okay? What the SBA loan does, it comes in to take care of that remainder piece of that to put the home back together how it was before. Is that pretty much clear how that works? All right. So with that being said, the SBA disaster loan is a little bit different from the traditional SBA loan. In the private banking world, when a business owner goes to apply for an SBA loan, what happens is the loan doesn't come from the SBA, the loan comes from the bank. So then the bank actually works with the SBA guarantees a portion of that loan. In this situation, with the flood that we had last month, it's completely different. That money comes from the SBA. That's the SBA disaster loan. So when you pay that money back, you don't pay it back to the bank, you pay it back to the actual SBA. That's how that works. So the goal of the loan is basically to
get the person and the business owner back to where they used to be. It's from a aspect of a loan program that's low interest, generous terms, and trying to get the person back to the condition they were prior before the actual flood actually happened. So when this happens, there are several different types of declarations. So you ever notice when there's a Katrina or there's a flood that happens, the first thing someone says, well, what's the government going to do? We're waiting on the government to come down and actually do something about that situation. When those events happen, it goes through a declaration. So it's not like it's something that happens and someone just make a phone call and all of a sudden funds come falling out the sky. It has to go through a process. Okay? So those processes happen. For example, Katrina is considered a presidential disaster. It's a national disaster. But you also have individual assistance, you have public assistance, agency, governors, secretary of agriculture, and military. So what that means is that, for example, if there's a bad winter freeze and the crops in a certain part of the state don't make it, well, they can do an agricultural loan to take care of that piece of that portion. But in forest, like the flood that we had last month, that affects everyone, business owners and homeowners. So how much can you actually borrow in these cases? So has anyone applied for an SBA loan, disaster loan? You applied for one, ma'am? All right. Have you gone through the whole entire process already? Not all of it? Okay. You applied for one as well? When you apply for the loan as a homeowner, the max you can get is $200,000 to repair your home itself. Also, you can receive $40,000 for your content. So for your contents inside your home, that's $40,000. As far as your home structure itself, that's $200,000. If you're renting a property or if you're a renter, you can also apply for the contents, which is $40,000. In reference to your small business owner, they can actually apply for something for as much as $2 million for their business. There's also two different types of loans. There's a loan that's inquired for the actual business itself, or as the property is concerned. There's also something called economic injury. Economic injury is when that person goes through financial disruption of their business. So for example, let's say you had a business and no water touched your business at all. It was fine, it was high and dry. But let's say, for example, let's use the flood. There's a bridge that connects your business to town. So now buyers can't get to your business. So even though you had no injury at all, no property damage, nothing wrong with your business, if buyers can't get to your store, to your business to basically spend money, then you lose money. Okay? So if you lose money, you can apply for what's called economic injury. And with that amount of money, that's capital to basically get your business back up and going. Even though you didn't have a flood at all, you had no water damage whatsoever, you had no business coming in. So that's economic injury when you apply for that. So we see a lot of business owners starting to apply for that right now, just because I had a doctor's office here the other day who had no water damage at all, but he lost patients. Patients couldn't get to him. So he lost, just from the flood alone, probably over $30,000 just from that short span of time. So he has to try to recoup that some type of way. So he has to go get a loan from probably his bank, probably maybe, just to basically go put that money back into his business, to take care of the business, to go ahead and put payroll. Do we have any small business owners here today? Okay. Now, we get a lot of questions at the Small Business Development Center about the credit requirements for the loan. You have a question, ma'am?
We rent a house, so
Okay.
we had to do a loan, so how much is the maximum?
It's $40,000.
40,000?
Yes, ma'am.
Just for the building?
It's for your contents inside the home. Because you don't own the property itself, you're renting it. Oh, you own the property. Okay, so you're renting the property out to someone.
Yes.
Okay, so that's like a business then.
Right.
So that's a different aspect of that. So you can apply for the normal traditional business loan. The property damaged to a certain extent, or?
Yes.
Okay. It flooded. Okay. So you're applying for that. That's not actually a renter. That's actually a business. So you actually earn income off of that. Right. So you're renting that property out.
So what's the amount that we can borrow for that?
You can go up to $2 million. It just depends on your situation, though.
Okay.
But $2 million is the max if you are a business.
Okay.
Okay, someone else had a question? I thought someone had a question. Okay, sorry.
So it is talking about collateral, and at the bottom it says SBA will not decline a loan for lack of collateral, but requires you to pledge what is available. Do you have to sign a CG pledge and everything that you have?
It depends on what you have available. They like collateral, they like land, they like real estate, what the SBA likes. If you don't have that, they look at other options. It depends on the person's situation. They could use a car, for example. But land and real estate is what they really, really like. But if you don't have that, it does get a little bit more technical, depending on the person's situation.
You're talking about that, like for example, a renter that's looking to replace contents in the vehicle, they could use the vehicle, or whatever the replacement of the vehicle, they could have that new vehicle be used as collateral.
If you're a renter, that vehicle actually is going to apply towards your content, actually.
Okay.
So if you're
So it's a-
renting property.
It's a different animal then?
Yeah, so there's two sides. There's homeowner side, and then there's the small business side.
Gotcha.
So a lot of people aren't aware, as a small business owner, you have that portion of it. But as a homeowner, even if you don't own a business, you can still apply for an SBA loan. So a lot of people think that it's SBA is Small Business Administration. I can't apply. I don't have a business. But if you own a home, you can apply.
All right, thank you.
Could you expand a little more on collateral?
Okay.
Prior to the flood, the disaster, when you're doing a general SBA request for money, you had to have so much collateral. They even took your silverware in your drawer as your collateral.
Yeah.
Well, how's the collateral now handling with this type of loan?
It's funny you said that. If you don't have the land or real estate, they do look at other aspects. Sometimes things of that nature, jewelry, things of that nature. It depends if it's functional. So it kind of depends on the value of those things. And so it's basically specific on each person, but it does get a little bit different. So if someone who has, let's say, they don't have land or real estate, but they have expensive, very, very fine expensive jewelry, per se, they may take a portion of that, or a portion of the value of that to pledge against that. If you don't have those two other items, just ma'am, it can be required.
I see here that only SBA, which is typical of any business who needs some funds. How would you compare that to the acronym DSBA? I thought that would give some leniency, what this lady is talking about because of the exigent circumstances.
I'm not quite understanding the question.
Just, a regular SBA.
Okay.
And disaster. I thought that D was on there for leniency that you would meet the threshold, that's a burden.
Sure, I understand. It is a little bit more lenient because of the disaster, but like I said, it does, a case-by-case scenario. When we look at those cases, I don't work for the SBA directly. We work in conjunction with the SBA, and every person's situation is a little bit different. We do see in cases of disaster, though, they are a little bit more lenient than your traditional, traditional SBA loan. So it seems to be a little bit more forthcoming in funds with the disaster program because of the situation that people are actually in. Events like this happen. The traditional SBA loan is a business owner who's going to apply for a loan for their business. In a case like this, it's typically a homeowner who's lost everything. And it's a business owner that lost their home and their business.
With the disaster SBA loan, does that include churches also that was?
Yes, ma'am, it does. Yes, ma'am. And for churches, and we'll talk about that in a second, the rates are a little bit different for churches. Churches and nonprofits have a different interest rate. They're treated just a little bit differently. More favorable interest rate, and we'll talk about that in a second. Any more questions? So in reference to the interest rates, the interest rates are calculated two different ways. There's when credit is available and when credit is available elsewhere. So what does that mean? So for example, let's take a business owner who's done very, very well. They have great profit and loss, high credit scores, done very good in profit last year. That person can actually go to their own private bank. So those business owners who have, let's say, a personal banker, they can get on the phone, call and say, hey, I need $200,000 XYZ, and I'll come sign my papers on Friday. But that person can still qualify for an SBA loan, but the rate's going to be a little bit different. That person's rate's going to be higher because the goal of this is actually to help those individuals who need help. So if you can go to your traditional bank, the rate through the SBA is going to be higher because you can get a lower rate through your traditional bank. But for the individuals who don't meet the debt ratio aspect, who may not qualify for as credit, when they go through the SBA, thus, whereas no credit available elsewhere, they can't go anywhere else to get that loan. So they don't have the finances to basically qualify at their traditional bank. They might not fit the bank's threshold. So through the SBA, the rate's going to be just a little bit less. And for homeowners, it's going to be 1.563. And we talked about churches a little bit earlier. Those rates are a little bit less for the churches compared to the traditional business. Yes, ma'am.
When you talk about not having credit available elsewhere, what does that mean? For instance, if it's a small business owner who can't get a loan because they can't get fire insurance on the business, is that one of the?
No, it depends on for its credit and propensity to pay back the loan.
Okay,
So
the credit history is great, but the bank won't give you a loan.
in that case like that, from a credit aspect, they still may qualify for the lower rate. So in that situation, it's not depending on, that's on a situational aspect.
Okay.
Not based on their credit and their finances, on their P&L.
So if you have a
homeowner who has good credit, then they're not supposed to be destroyed, so SBA can turn them down and say, hey, you need to go to Whitney Bank because there's no reason Whitney Bank won't give you a regular loan.
No, an aspect of that's a little bit different with the homeowners. This is compared to business owners.
Okay.
Yeah, so the homeowner is a little bit different. The business owner is compared to, let's say, them applying for a normal business loan. The qualifications based upon. Yes, sir.
How do they establish credit available? How do they establish credit available elsewhere? Do they require you to show a denial, or can they do a financial underwriting and just cash flow and determine you're not going to qualify for the amount of revenue that you have and then the amount of debt that you have? You're not going to qualify for other.
It's based upon underwriting. Only underwriting. Okay. Any other questions? So in reference to the restrictions on the loan eligibility, basically what the SBA loan is going to do for disaster recovery, it's going to cover those aspects that you don't have insurance on. So if, let's say, for example, your insurance company does pay a certain amount and you still have damages for a remainder amount, the SBA loan comes in and takes care of that difference there. So someone say, okay, well, FEMA gave me this much, my insurance company gave me this much, I have $25,000 worth of damage still to do in my home. What am I going to do? So the SBA can come in and take care of that portion that the insurance company does not cover. The type of properties that are not covered are pretty much second homes, pleasure boats, airplanes, recreational vehicles, things of that nature. As far as the compliance aspect goes, if a business owner goes to SBA prior to an event, prior to a disaster, and they apply for a loan, let's say 3 years ago, did not keep insurance on that loan. When it's time for them to come back and do another SBA loan, the SBA can say no, because you didn't follow the rules on the first loan. Now, it doesn't mean you have to have insurance on your business to basically get an SBA loan, but when you sign your documents, depending on the disaster, for example, we had a flood here last month, so if you had a lot of flood damage, the SBA is going to require that you have flood insurance on the business. So if you did not keep that flood insurance, and here is 3 years later, you want to apply again for an SBA loan, well, they're probably going to deny that loan. Now, of course, refinancing, what happens in certain situations, the individual may say, well, I have my payment at this amount right now. I'm not going to basically I'm gonna stay in the home. I'm going to repair the home, but I want a lower payment. So the SBA can actually come in and still get your payment down lower by doing a refinance, even on the business as well. In the aspect of the business, they take a look at the equipment, take a look at the materials inside the business, and they can use that as collateral as well. Oh, sorry.
I'm sorry, just a real quick question. You said about the SBA as far as them not renewing a loan, not approving another loan for you.
Sure.
Do they force place insurance then at the time that they loan you the money, or do they just let the business owner get their own insurance?
Deny it, yeah. So they don't force place because they're not going to print the documents.
Okay.
I think it was back on the screen before, but are you saying that a person, I was trying to read it right fast and copy it, like homes, the second one, homes may be eligible for refinancing existing. If a person has, say, a person had just purchased the home, they had never moved into the home, and they still have their payment, the disaster SBA can take over the whole thing and refinance the loan for that individual?
Yes, ma'am. You can still refinance the property. The person chooses to refinance the property. It depends on their debt ratio, depends on what they qualify for as well. Because let's say this person did a home, let's say, for example, they did 100% financing. Their rate is higher for whatever reason. They have a higher interest rate. Now, due to disaster, they say, well, I want to do my home under disaster recovery. They may qualify for a lower interest rate because of the disaster situation. That person might have had 100% financing to begin with at a much higher interest rate, didn't put any money down. And now, because of the storm, they can actually come in and get their house refinanced at a lower interest rate. So taking advantage of the situation per se.
Okay, because that's what I was trying to copy it down. I just wanted to make sure that it was correct, but I was seeing up there that you can't refinance your house.
Yes.
The person never moved in.
Okay. Sir?
Conforming mortgage financing like 2836, are you saying that with an SBA home finance, you would be able to have higher debt ratios?
It depends on the situation for the actual borrower itself and their debt ratio. Sometimes they can go up to a higher debt ratio or higher loan to value per se. Depends on every person's situation and their income value. So it's unique according to each borrower. Yes, sir.
Trying to get to the nuts and bolts of this thing.
All right.
I'm in a situation where I think it's typical lease, rent-to-own type rental property.
Okay.
That, I had all 3 units rented. But the owner that I'm, purchasing the property from,
Okay.
she maintains the insurance. We do not have access to it. We cannot negotiate it. We pay half the insurance. We pay half the taxes, and I pay my note.
Okay.
So who's responsible for repairing or securing an SBA on this rental property?
Who holds the mortgage?
Pardon me?
Who holds the mortgage to the property? You're saying you're buying the property from her with the actual.
I'm purchasing the property.
Is she a private lender? Is she?
Pardon me?
Is she a private lender or someone else?
She's a private lender.
Okay, she's a private lender.
Uh-huh.
So she holds the mortgage technically.
Well, yeah.
Okay. So she is the lender.
Yeah, I'm paying her.
You're paying her.
Right.
Okay.
So
I think I can help him. I think what you're talking about is like a bond for deed.
Gotcha.
Yeah.
Right. So in a bond for deed, you don't get title to the property
Until it's complete.
it all out.
Yeah.
Exactly.
But she's saying it's still the owner.
So when it's a bond for deed, if there's a mortgage, if there is an actual mortgage on the property, a bank is supposed to be an escrow agent to disperse the payments so that the mortgage is paid and the owner is paid. If there isn't a mortgage on the property, there is no requirement that a bank be an escrow agent. So essentially, she is like the lender.
Gotcha. Yeah.
She's like the lender in that situation. But unlike a situation where she owned the property and sold it to him, where she put a mortgage on it and he becomes the owner, in a bond for deed, she is still the owner. And once he makes all the payments, then
He becomes the owner. Yeah.
So that's a little different situation. So technically, what you have is a really kind of complicated situation because for the tax exemption purposes, you're supposed to be listed as the owner, so you get the homestead exemption. So in other words, you're not supposed to be paying.
that's the homestead exemption on rental property?
Yes, you can. You can if you do a bond for deed, technically correct. What happens is you're listed as the owner for the property tax purpose. You're not the owner in title, but for property tax purposes, you're listed as the owner.
We both share the tax.
I understand you may be sharing the taxes, but all I'm saying to you is,
Tax is not in my name.
and so what that means is that however the transaction was done, they didn't record you as the owner for property taxes. What's supposed to happen is you're supposed to be the owner for property tax to take advantage of the tax, essentially a homestead exemption. So what you may be doing, again, because I haven't looked at that, you may be overpaying property taxes because you could have qualified for the homestead exemption, and therefore, if you qualify for the homestead exemption, you might have said, forget you, I don't want you to pay my property taxes, I'll pay my own, but because you don't technically qualify, that's probably why that split is going on.
Okay, I give her all that. Now that the storm came and damaged the property, who has to?
Well, my first question, did you have flood insurance?
No, she didn't have flood insurance.
All right, and you didn't have flood insurance.
Well, I don't know what insurance you had.
That's what I'm saying. So you did. That's what I'm saying. So you didn't have flood insurance. So I think what's probably going to happen, FEMA has to make a decision to either treat you as a renter or as an owner.
Yeah, that's why I came here to find out that.
That's right. So
I'm not FEMA, I'm not SBA,
so here's what I'll say. We're gonna probably have to look at some documents. We have to let our clinic. I'll give you the number 771-3333. Get an appointment. Let's look at all your documents, and then we can make a better determination. Because what's critical here is what did you sign?
Yeah, that's true.